Good morning and welcome to our live webinar. Today, we will look at the recent government proposals from the UK Immigration White Paper published on the 12th of May and what this means for employers and migrant workers. Thank you all for joining us. I'm Imelda Reddington, Partner and Head of Immigration at Field Seymour Parks. Joining me today are my colleagues Callum de Freitas and Victoria Ounsworth, both joint solicitors in our immigration and employment teams. Now, before we get started in the content, I'd like to cover some housekeeping details. This webinar is being held remotely, so please do bear with us should we experience any technical difficulties. We will aim to resolve these as swiftly as possible. Our session will last for 1 hour with some time after the presentation to ask questions from the panel. If you have any questions during the session, please add them to the question box on the platform. We will endeavour to answer as many as we can at the end of the presentation. However, any we cannot answer during the time permitted, we will follow up by email afterwards. Now, there will be polls as normal throughout the seminar, so please do get involved with these. The slides from the webinar are available to download whilst the webinar is in session in the handout section. Now, it is being recorded and the recording will be sent to all attendees later today. And finally, we have a short survey which will automatically pop up at the end of the webinar. Your feedback will help us with future events and topics. And as a thank you for completing the feedback survey, we will enter those names into a prize draw for a £50 John Lewis voucher. So it's important to consider the background of the white paper proposals and why we are seeing more stringent measures to reduce net migration. Immigration is a political hot topic, with each party having their own agenda. It was the fourth most important issue pre-election for the UK public and political parties alike. Now, from the public's perspective, the lines are possibly blurred between legal migration, which supports the UK economy, and illegal migration, which are the small boats arriving daily to our shores, plus asylum seekers, many of whom are already in the UK. Now, interestingly enough, the number of small boat arrivals increased 14% this year compared to previous years. Now, having said that, net migration has fallen from 860,000 in 2023 to 431,000 in 2024. Now, the Conservative government had already introduced numerous changes which has had an impact on these numbers, notably banning dependents from joining students and care workers, and of course the substantial increase to the minimum salary requirement in April last year. Now, there has been an increase in enforcement action against sponsors, employers and workers. Last year, the UK VI deployed 1,000 additional employees to the enforcement teams. We've seen an increase in action against sponsor licenses. For example, in 2024, we saw almost 17,000 licenses suspended and almost 15,000 revoked. Now, compare that to the previous year, where we saw around 570 licenses suspended and around 340 licenses revoked. Civil penalties and fines are also on the rise. We saw a whopping 18.5 million issued in 366 penalties. Now, this is an average of over £50,000 per penalty. Now, we are definitely seeing the impact of the tripling in fines that came into force last April, from £20,000 up to £60,000 per worker who's found to be employed illegally. We saw a report at the weekend demonstrating that illegal worker arrests were on the rise. From July 24 to May 25, we saw nearly 6,500 people being arrested on suspicion of illegal working. That's an increase of 51%. In the same report, we have heard that around 30,000 individuals have been removed from home countries. In terms of immigration fees, we've already seen a substantial increase to the immigration healthcare surcharge around 18 months ago. Well, we've also recently seen an increase in visa fees and sponsor application fees, ranging from 5% up to over 100% on sponsorship costs. Now, we are also promised to see an increase in more immigration fees, and Callum will talk about that a little bit later, particularly the immigration skills charge at 32%. Now, the Migration Advisory Committee were commissioned to review international recruitment for IT and engineering professionals, as the government suggested that these sectors have historically been amongst the heaviest users of international recruitment. However, the report published at the end of May found that the usage of the immigration system is broadly proportionate to the size of the IT and the engineering sectors, and that a recruitment is only responding to the demand for the UK skills shortages in the UK labour market. The report also went on to say that migrants in these occupations have a positive physical impact in the UK, and the UK benefits from healthy growth in the IT and energy sectors. Now, the Migration Advisory Committee found that there is no guarantee that improving domestic skills would automatically reduce the demand for visas, absent changes to the immigration system. Now, perhaps this was not the outcome expected, but I think we can anticipate similar reviews to other sectors who do rely on labour from overseas in the future. With the increasing reliance on migrants in the care sector, and the discovery of rogue operators in the care sector, which led to thousands of displaced workers in the last couple of years, new rules have been imposed on care businesses to recruit from this pool of displaced care workers. I will look in a little bit more detail at that a little bit later. And finally, the sceptics amongst us may think that reforms UK success in the council elections on the 1st of May had some influence on the white paper, given the publication timing. The government's immigration white paper does propose some tough measures to reduce our reliance on migrants from overseas and to make it more difficult for those in the UK to settle here. Perhaps the tough stances was a direct result of the losses in reform. Who knows? Now, enough from me. I'm going to move straight over to our first poll, so please do get involved. So before we go into the detail of the white paper, a simple question: have you read it? You have 4 options. You've read it front to back. You've skimmed through it, focusing on certain sections. You've read summaries in new articles, or this is the first time hearing about it. I'll give you a moment to place your vote, please. Okay, that's very interesting. So the vast majority of you have read summaries and new articles, and quite a number of you, surprisingly, is the first you're hearing about it. So we do hope today you'll go away learning a lot more about the white paper compared to when you arrived. So let's first look at the headlines. So the key topics we will cover today in the white paper, which will potentially impact any employer or business who employs migrant workers and their family members, covering the cost of renewing of visas, funding visa expenses. The additional administration and compliance will be an added burden for sponsor employees, whereas other employers may find that key individuals are wanting to leave the UK due to some of the proposals in timelines for achieving settlement and the costs that come with it. So the key areas we will focus on today is settlement, the increase to immigration skills charges, and the skill level increase. Callum will cover those topics. And then we will move to Victoria, who will cover the graduates, the high potential scheme, and the new requirements for the English language. Then I will talk about the proposed changes to the care sector. So there are headlines today. I will now hand you over to Callum, who will conduct another poll before continuing with this content. Thank you very much. Over to you, Callum.
Thank you, Imelda. My section of today's talk will focus on the changes to settlement and sponsorship, as Imelda mentioned. But before getting into that, I thought it might be worth running another quick poll to assess the direct impact of these changes on today's audience. The question for today's second poll is, do you know someone with a visa in the UK? Now, that could be a friend or family member, but it could also be an employee in your business or a colleague at work, or even you personally if you have a visa yourself. So the options on screen are: yes, I have a visa; yes, I have family or friends with visas; yes, employees/colleagues of mine have visas; or no, I don't know anyone with a visa. So I'll give you a moment to put your answer in. It's quite interesting results again. Obviously, quite a few people with employees or colleagues at work who have visas. We have seen a big uptake for the skilled worker visa, which I imagine makes up the bulk of those. We also do have a real spread. We have people with visas themselves, people with family or friends with visas, and then a few also who don't know anyone with a visa, but hopefully you'll still find today's talk interesting. We'll now move on to discuss the changes to settlement. Now, for the purposes of today's talk, I'm going to use the terms settlement, permanent residence, and indefinite leave to remain interchangeably, all to refer to a right to live and work permanently in the UK. Now, currently, there are several visas which allow an individual to apply for permanent residence once they've lived in the UK for a set period of time. For most of these visas, the qualifying period for settlement is 5 years, although there are some visas which provide a quicker route, such as leaders on the Global Talent Visa, who can settle after just 3 years. However, this is all set to change, as the white paper confirms that the standard qualifying period for settlement will increase to 10 years. And this means that most visa holders will have to live in the UK for a decade before they can apply for permanent residence. Now, that obviously isn't good news if you were looking at applying for a visa in the future. But what is especially concerning is the possibility that this new rule will also affect those who currently have a visa, meaning that someone who has already been in the UK for years could suddenly find themselves having to wait an additional 5 years before they can apply for settlement. The White Paper's technical annex states that a number of those currently in the UK are likely to leave due to it taking longer to gain settled status. And this, of course, suggests that the changes will apply to those who are already in the UK. In addition, recent BBC and Financial Times reports, which rely on unnamed government sources, claim that the government is planning on publishing a follow-up to the White Paper. Allegedly, this will confirm that the 10-year qualifying period will also apply to people already in the UK. For the time being, we don't know for sure, but our expectations based on the technical annex and the BBC and FT reports are that the 10-year qualifying period will apply to those who are already in the UK, or that this is at least the government's current plan. The aforementioned BBC and FT reports do indicate that there may be special mitigations put in place for individuals who are particularly close to reaching the current qualifying period of 5 years. So, for example, if someone had been living in the UK for 4 years and 9 months when the new rule is introduced, then they might be allowed to apply for settlement under the current 5-year rule rather than having to wait the full 10 years. However, this is just a guess as to how this mitigation might work, as the white paper doesn't provide any detail on this. Now, having said all of that, the white paper does clarify that there will be some exceptions to this new 10-year qualifying period. For example, dependents of British citizens will still be able to apply for settlement after 5 years. The white paper also says that visa holders who make a significant contribution to the UK economy or society may be able to settle after just 5 years rather than 10. However, it's not yet clear how these contributions to the UK economy or society will be assessed. Will this be based on salary or on the type of role that somebody works in? Or will there be a more detailed assessment, taking into account an individual's involvement in their local community or with charities, for example? Now, the former option would seem too simplistic and likely to create a two-tier system where higher paid workers can settle more quickly. The latter, however, is likely to create further admin for both applicants and the Home Office and slow down the processing of applications. I should flag that people with pre-settled status under the EU settlement scheme are expected to be unaffected by these changes. Under Article 15 of the UK-EU withdrawal agreement, these people have the right to apply for permanent residence after 5 years. If the UK government were to require these people to stay in the UK for 10 years before applying for settled status, then that would undermine the withdrawal agreement. Now, such a course of action from the government seems unlikely, given the recent positive talks between the UK and EU. However, for most visa holders, it does look like the new qualifying period will be 10 years. This will necessitate additional visa applications to extend for the full 10-year period, as currently the longest you can get on most visas is 5 years. With additional visa applications comes additional costs, both in respect of multiple rounds of visa application fees, but also in having to pay the immigration healthcare surcharge for 10 years rather than 5. Now, the healthcare surcharge is currently £1,035 per year for most people. So once this new rule is introduced, there will be over £5,000 of additional costs in respect of just the healthcare surcharge. We've reviewed the figures and have calculated that the total cost from the point of entering on a skilled worker visa up to applying for settlement will increase from roughly £9,800 today to around £16,700. However, the cost of these changes will not be borne just by individual visa holders, but also by employers. We've got another quick poll now, as I wanted to get a sense of how many sponsors we have in attendance today. And by that, I mean any business with a sponsor license which can be used to hire migrant workers on work visas. So the options for this poll are: our business has a sponsor license, or we're considering applying for a sponsor license, or we don't have any plans to get a license. And then option D is I'm an individual, or I don't know. So I'll give you a moment to give your answer to that question. As I say, sponsor license helps you hire migrant workers, sponsor migrant workers so they can get work visas. So interesting results again there. We've got over half of those in attendance today do have a sponsor license already, and so are likely to bear the significant brunt of these changes that I'll get onto in a moment. And then we've got a few mixed results, some considering applying for a license, some with no plans to, and then a few who aren't sure. We'll move on to the next slide now. Currently, sponsors must normally pay the immigration skills charge when sponsoring workers on the skilled worker and senior or specialist worker visas. Now, there are some niche exemptions, but I won't get into the detail on those today. The skills charge is paid upfront as a lump sum and is calculated based on the length of the sponsored worker's visa. So if a worker is applying for a 5-year skilled worker visa, then their sponsor must pay for 5 years worth of skills charge upfront. The skills charge does need to be paid by the sponsor, and it cannot be passed on to the worker, or the sponsor will risk having their license revoked. Now, the white paper is proposing a 32% increase to the skills charge. For small companies, that would mean an increase from £364 to £480 per year of visa. So for a 5-year visa, that would be £2,400 rather than £1,820. For medium and large companies, the skills charge will increase to £1,320 per year of visa, meaning that for a 5-year visa, they will go from paying £5,000 to £6,600. We also need to keep in mind the settlement changes. Now, if an employer wants to sponsor an individual from their entry into the UK up until settlement, then they will need to sponsor them for 10 years, which also means 10 years of skills charge. For a medium-sized sponsor, the minimum cost of sponsoring a skilled worker from entry into the UK until settlement will go from £5,525 today to £14,250, so nearly tripling. And that's only including the fees the sponsor is legally required to pay themselves. However, many sponsors also cover other visa-related fees for their sponsored employees, as this can help to attract the best talent. Currently, the cost to a sponsor of paying all of these fees for a skilled worker from entry until settlement would be around £12,250. But after the white paper's changes are implemented, that will shoot up to £28,000. Now, these significant cost increases are going to make it much more expensive for employers to sponsor workers, with the more dramatic impact being on medium and large businesses. Now, if you're a sponsor who has historically fallen into the medium or large company categories, one thing I would recommend looking into is the recent changes to the company size thresholds. These changes have the effect of increasing the proportion of companies which are classified as small. If your business now falls within the small company definition, then you can pay the lower rate of skills charge and even claim a partial refund of any skills charge that you've already paid at the higher rate, though only if you report this change in size to the Home Office. We've got an article on this on our website if that's something you're interested in looking further into. Moving on, the white paper also proposes increasing the required skill level for skilled workers from RQF6 to RQF6. From RQF3 rather to RQF6. Now, to put that in plain English, this means that roles will only be eligible for the skilled worker visa if they require knowledge and skills equivalent to a bachelor's degree. As a result, it's expected that around 180 roles will cease to be eligible for the skilled worker visa, and that's sourced directly from the white paper. Now, I've listed the types of roles and sectors that are most likely to be affected on the slide, and these include non-corporate managers and proprietors, as well as a number of roles in the STEM fields. Health and social care roles will also be affected, though Imelda will speak more about that later on. For some sectors and businesses, it may remain possible to hire skilled workers, but only in more senior or highly skilled occupation codes. However, for some other industries, these changes are likely to render the skilled worker route a complete non-starter. One silver lining is that these changes will only apply to applicants from overseas and those who are switching from other visas. The changes won't affect those who are already in the UK on a skilled worker visa, who will be able to continue working in occupation codes below RQF6. And that means that if you are able to sponsor someone as a skilled worker in one of these roles before the skill level changes are implemented, then they will be able to remain in that role as a skilled worker for as long as they stay in the UK. My next slide addresses the impact on salaries, as the increase in skill level to RQF6 won't just affect the number of eligible roles for the skilled worker visa. There'll also be a knock-on impact on the skilled worker visa's minimum salary threshold. We're expecting this to rise from the existing £38,700 to around £50,000 per annum. In tandem with this, the white paper proposes to scrap the short-lived immigration salary list, which currently allows for a narrow selection of roles to be paid below the normal salary threshold. Now, this change will affect biological scientists, archaeologists, graphic and multimedia designers, lab and pharma technicians, and roles in the creative industries, who will now all need to be paid the much higher general salary threshold rather than the current reduced rate. In its place, the white paper proposes introducing a new temporary shortage list. Now, this would offer time-limited access to skilled worker visas for certain shortage roles below RQF6. The white paper is clear that roles will only be added to the temporary shortage list if they're considered key to the UK's industrial strategy or to delivering critical infrastructure. So the usefulness of this list will really depend on how widely that requirement is interpreted. If a wide interpretation and approach is adopted, then there may still be some scope to recruit skilled workers in roles below RQF6, at least temporarily. Moving on now to consider these proposals in the round, we're expecting there to be a significant impact on sponsors. It will be much more difficult to recruit skilled workers from overseas, what with the narrowing of the available roles and higher minimum salaries. In certain sectors, the skill level changes may make it almost impossible to hire from abroad. The cost of sponsorship will also dramatically increase, both when recruiting from overseas and when sponsoring skilled workers who are already in the UK. The 32% rise in the skills charge, coupled with higher salary thresholds, means that the total cost of sponsorship will be significantly higher. And that's not even taking into account the new 10-year qualifying period for settlement. Now, if you want to sponsor someone all the way from entry into the UK until settlement, you'll be paying these increased costs over a longer 10-year period. There'll also be a greater administrative burden on sponsors. Sponsors are required to keep detailed records relating to their sponsored employees and report on their activities and any changes in their circumstances. Now, having to do this over a 10-year period rather than the current 5-year period will mean that these record keeping and reporting duties will be relevant for a longer period of time. With all that said, we do unfortunately expect that these proposals will impact on all employers, not just sponsors. The increase in skill level to RQF6 will create skills shortages in affected industries, impacting all employers in those sectors, regardless of whether they have a sponsor license or not. So if, for example, your competitor would have previously sponsored a skilled worker to fill a role within their business, but they can now no longer do so due to the skill level changes, then they would now be competing with you for the same domestic workers. However, we anticipate that there will be skills shortages in not just the sectors that are directly affected by the skill level changes, but also across the board. The increased settlement qualifying period of 10 years will make moving to and staying in the UK a much less attractive prospect. 10 years spent on visas is an awful long time, particularly with the risk of having your visa curtailed or revoked for all sorts of reasons, for example, loss of employment. This precarious 10-year wait might not be seen as worth it by many prospective and current visa holders, and the white paper itself foresees a decrease in the number of visa applications, as well as some existing visa holders leaving the UK. Now, it's important to remember that the 10-year settlement path will affect almost all visa categories, so the impact won't just be limited to the skilled worker visa or to particular industries or sectors. And we can therefore expect a marked reduction in the number of workers across the board, with fewer visa applications from overseas and more people leaving the UK when their current visas expire. This, coupled with the higher salary thresholds for the skilled worker visa, is likely to result in wage inflation, as employers fight it out over the smaller pool of talent in the UK. I'll now hand over to Victoria to talk about the changes to the graduate visa.
Thank you, Callum. Good morning, everyone, and thank you so much for joining us today. So the graduate visa, as we know it, is also due to change under the white paper. So currently, the graduate visa allows international students to remain in the UK for a further 2 years after the completion of their studies, or for 3 years for the case of PhD and other doctoral students. Graduates on this route are not immediately expected to obtain employment with a licensed sponsor immediately after finishing their course. They can, if they want to, just use this time to consider their options and find an appropriate role, even if it takes them 2 years to do that. As a result, many graduates will switch to a skilled worker visa at a later stage when they have secured appropriate employment. Now, this role has been under scrutiny for some time. The white paper purely reiterates some of those pre-existing concerns, namely that the number of international students remaining in the UK on the graduate route without finding suitable employment within an appropriate period of time. In other words, they're taking too long to find high-skilled employment after the end of their studies. So the white paper proposes to reduce the length of the graduate visa down from 2 years to 18 months. The hope that this will incentivize international students to obtain graduate level roles quicker or return to their home country if their intention is not to obtain employment in the UK. Now, the white paper goes so far as to recognise the valuable contributions that graduates make to the UK economy, but equally suggests that it is important that those who stay transition into graduate level jobs and properly contribute to the economy. So it's not yet clear whether this change will affect PhD students, nor whether it will apply retrospectively or not, but we do feel that this would be quite unlikely at the current stage, similar to the changes with settlement as discussed by Callum. In particular, large employers such as the NHS, for example, is likely to want clearer guidelines on how this is going to affect their graduate level roles, which for the NHS is grade 5 and above. It will be interesting, however, to see whether those changes will apply to those already in the UK on student visas, and whether they will be able to apply for that 2-year visa rather than the 18 months. Equally, that change could lead to some unintended consequences, making graduate recruitment slightly less desirable, perhaps, for employers. That initial 2-year period is often a very useful period of time for an employer to determine whether they wish to retain that individual, invest further sponsorship fees in retaining them. Some may suggest that 18 months is not a sufficient amount of time in which to do that. We had previously anticipated that the white paper would seek to introduce certain qualifications for international students to qualify for a graduate visa, for example, a requirement to apply for or obtain a graduate level role, but that's yet to be seen. Perhaps conversely, the white paper confirms the government's intentions to continue to support applicants and preserve the high potential individual visa route, or the HPI route as we often refer to it. It's designed to attract graduates from top-rated universities to come to the UK and drive economic growth. It will give the applicant permission to stay for 2 years and 3 for those who have a PhD or other doctoral qualifications. However, the HPI route is not one which counts towards settlement. To apply, applicants must have been awarded a qualification by an eligible university in the last 5 years. It isn't possible to extend a HPI visa, but individuals can switch to other visa routes, for example, the skilled worker route. Now, there are currently 42 institutions on this list, and between May 2022 and June 2024, approximately 4,500 visas have been granted in this route. Applicants that have already been given a graduate visa, for example, or in the UK on a doctorate extension scheme are unable to apply for a HPI visa. And as it stands, those on graduate visas would not be able to switch to a HPI visa either. Unlike most of the other white paper changes, the change to the HPI route doesn't appear in line with the government's overall target of reducing net migration and could in fact lead to the opposite effect. The white paper proposes to double the number of qualifying institutions on the HPI route, opening the route to a wider range of individuals. Combined with the changes to the graduate route, this would indicate that the government are looking to adopt a more selective attitude to those who are permitted to enter and remain in the UK. The other advantage of the HPI route is that dependents are able to join a successful applicant, whereas this is not possible for those on the graduate route. It's unclear as to how the government intend to cap this expansion. We don't yet know which institutions will be included, whether the changes will be based on global league tables, for example, or whether the government will instead focus on considering a wider geographical representation of institutions. As it stands, there are a few countries which dominate this list at present, and there are arguably as worthy institutions in other geographical locations. It could have the effect of making it easier for graduates from a wide range of universities to access this HPI visa. So with the change to settlement, this route may not be seen as desirable to those who ultimately do have a long-term goal of remaining in the UK, and applicants may decide it might be better to study abroad in countries where settlement is within arm's reach. So in that way, it could weaken the competitive edge when attracting global talent. Most HPI individuals will naturally command higher salaries given the nature of their roles, which correlates with a greater contribution to the economy, and so the competition for those roles is likely to increase. The white paper proposals create somewhat two-tier system between the graduate and HPI routes, whereby HPI applicants will be able to stay in the UK for longer. With the graduate route offering a reduced stay, this could lead to a decrease in international student recruitment, which could affect universities if students are ultimately choosing other destinations for their study. And equally, this change could even widen the skills gap in specialist areas. It may be that when the government releases more information about the criteria on which it may consider a reduced qualifying period based on contributions in the UK, for example, that HPI visas are taken into account here, but that remains to be seen. We're going to move on to the next slide to consider the changes in the English language requirement. So the white paper proposes numerous changes to the existing English language requirements. Firstly, the Common European Framework for Reference for Languages level, or CEFR levels, required for skilled worker visas and other work visas which already require that English language proficiency, will increase from B1 to B2. Whilst only a small increase, it does have the potential to catch people out. An example would be where an applicant passes their B1 level test shortly before these changes are implemented. This may then require them to take a further test at B2 level before actually applying for their visa. Secondly, a new English language requirement will be introduced for adult dependents of workers and students at A1 level, which is essentially a basic understanding of English. At present, there is no such requirements for these dependents to demonstrate an English language proficiency. This is a big change, which is likely to increase the demand for SELT, so the Secure English Language Tests, from approved providers. The white paper does suggest that the government will work with the Department of Education and local government to make it easier for those already in the UK to access these tests to meet the requirements, but this is likely to require some significant investment on their behalf. And unless the government makes some investment in this area and widens the pool of providers that you can take one of these tests from, it may slow the timescales for getting test appointments and receiving results across the board. A few of the other key changes in this area include the fact that there will be a new minimum standard of English proficiency at A2 level when extending any visa, so it's not route specific. Secondly, the proficiency for all settlement or indefinite leave to remain applications is due to be standardised at B2 level, regardless of the settlement route. The UK government believe that these changes are designed to improve integration with a view to encouraging an observable improvement in migrants' English language skills over time and hopefully to increase employment uptake in the UK. However, there is still some ambiguity over how these changes are going to be implemented to those already in the immigration system. For example, which routes will be affected by the B2 requirements for settlement? To what extent will it already affect those on a path to settlement? Arguably, those individuals applying for ILR have been living and working in the UK for at least 5 years, and so are likely to possess a high level of proficiency already. Will these changes impact those already in the UK or on family reunification policies? Will the requirement for dependents affect those on every work route? For example, will they apply stricter approaches to skilled worker dependents compared to those of GBM routes? We really don't know as of yet, and there are quite a few unanswered questions which we hope in time more guidance will come out on. So watch this space. However, I'm now going to pass on to Imelda to look at the changes in the care sector.
Thank you, Victoria and Callum. Very interesting proposals ahead. I will now look at the implications of the white paper for the care sector. It has been widely publicised. There are concerns about abuse and exploitation of care workers. The Home Office have recently been cracking down on the care sector with enhanced enforcement action visiting many care sector business premises. As a result, hundreds of care businesses have had their sponsor licences revoked. Now, we saw between July 2022 and December 24, 470 licences revoked, which affected 39,000 care workers. Now, currently, there are reported to be around 30,000 of these care workers without work or a sponsor in the UK. So, as a direct impact, the Home Office have invested millions of pounds into a recruitment scheme by creating several regional and sub-regional partnerships to support these displaced workers in finding suitable employment. And on the 9th of April, new rules were introduced, placing an obligation on care sponsors to first recruit from the pool of displaced care workers in the UK using these regional partnership schemes. However, it does appear that this scheme has not been that successful to date. A report from the Work Rights Centre reported that there were less than 3.4% in success rate in the placement of these workers into suitable employment. And then we also had a report from a Freedom of Information request from the end of April, revealing that only 941 of these displaced workers had found suitable employment. So it's yet to be seen whether these measures have gone far enough. Now, the white paper goes further, proposing an outright ban on the recruitment of care workers from overseas, which will have a significant impact on the supply of care workers to the UK. We don't yet know when this will be implemented, but we are already seeing the effect on requests for certificate of sponsorships for overseas workers. So as for care workers who are already sponsored in the UK and present, the current plan is that they will be able to continue to switch to and extend their visas until 2028, but not beyond that. The white paper does add that it will be kept under review. So it is possible that this deadline on switching and extending visas for care workers may take effect sooner than 2028 or indeed later. So some statistics, there are currently estimated to be over 130,000 vacancies in the care sector, which must be addressed. So by closing down this route, it may not be addressing the issues for this particular sector. So that concludes my update on the care sector. I will now hand you back to Callum, who will talk a little bit more about the timelines for implementation of some of these measures in the white paper. Over to you, Callum.
Thank you, Imelda. Now that we've outlined a few of the white paper's more significant proposals, I'm sure some of you will be wondering when we can expect these to come into effect. The white paper itself does not set out a clear timeline for implementation, but an accompanying press release confirmed that changes would be made during this Parliament. There were initially a few different interpretations of this phrasing, which could refer to the current parliamentary session, concluding at the end of July of this year, or to this Parliament's term, which will end in 2029. A follow-up research briefing published on the House of Commons Library has adopted the second interpretation, stating that the changes will be introduced by 2029 at the latest. However, it should be noted that this is just a research briefing rather than a direct government source, and so it is possible that their interpretation is incorrect. The only real update that we've received on timescales is in respect of the settlement changes. Home Secretary Yvette Cooper has said that further details on these changes will be set out later this year, and that there will be a period of consultation. It's therefore unlikely that the 10-year qualifying period will be introduced until towards the end of the year at the earliest, although it is possible that the consultation period may delay implementation until early 2026 or even later. However, we're still in the dark on the rest of the changes. What we can do, though, is look at the government's record on immigration timelines to date. For example, the recently introduced care sector recruitment rules that Imelda just mentioned were announced on the 12th of March 2025 and came into force on the 9th of April 2025, so a timescale of less than a month from announcement to implementation. Visa fees also increased on the 9th of April 2025, and these fee increases were only announced on the 19th of March 2025, so just a few weeks before coming into effect. What these examples demonstrate is that, on immigration matters at least, the current government is willing to make changes on very short timescales, without giving businesses or individuals much time to prepare. It should also be noted that some of the White Paper's proposals would not require an Act of Parliament to become law. Rather, the government could simply put forward a statement of changes to the immigration rules. This would allow the government to quite quickly implement the proposals without the opposition or delay caused by the normal legislative process. With all of this in mind, once we get further details on a proposal, we should probably expect it to come into force quite soon after. As discussed, there may be transitional provisions for some of the changes, which could help to make the implementation less sudden. Moving on, despite the gloomy outlook of this talk, there are some silver linings. For example, the White Paper does confirm that the government are looking at ways to invest in skilling up the UK's domestic workforce, which may help to address the anticipated skills shortages. However, there's no real detail on the government's plans yet, and we can also expect a significant delay before there's any tangible impact of this skills investment. No matter how much money the government puts towards this, workers are not going to develop required skills overnight. The White Paper also confirms that the Home Office are keen to promote the global talent route. This is a visa available to leaders and potential leaders in certain fields, such as digital technology and the creative arts. Unlike a skilled worker visa, the global talent visa does not require sponsorship and is therefore a quick and low-cost route to settlement. However, before applying for the visa, an applicant must first receive an endorsement from an endorsing body. The evidential requirements for these endorsements are quite burdensome. If the Home Office want to encourage more people to use the global talent route, then making it easier to get an endorsement might be the way to go. As you might have seen in the news, the Youth Experience Scheme has been announced following the recent talks between the UK and EU. This is expected to work similarly to the existing Youth Mobility Scheme, which allows young nationals from certain listed countries, including Australia, New Zealand and Canada, to come to the UK for 2 to 3 years without a sponsor. I'd be interested to get an idea of how popular people think the existing Youth Mobility Scheme is. So if we could move to our next poll. Now, to be clear, I don't expect anyone to have done any revision before this, but please do have a guess at the 2024 figures for the Youth Mobility Scheme. For reference, if this helps, the annual cap on these visas is 81,100, and that's split across 13 participating countries. So the options are A, 24,400, B, 39,100 visas, C, 62,800 visas, or D, 81,100 visas, so the cap was used up. I'll give you a moment to answer that. So range of guesses, we've got a few for about a quarter of people for 24,400, similar for 62,800, a minority saying that the cap was used up, and then most people saying, or a plurality at least, saying 39,100. The reality is that only 24,400 of these visas were used. So clearly there hasn't been much take up for the Youth Mobility Scheme, which is quite surprising given the flexibility it affords young people when coming to the UK. Returning to the slide, it remains to be seen whether the Youth Experience Scheme will be any more successful. There is potential for this scheme to help address skills shortages by offering a temporary route into the UK for young Europeans, but it's unlikely to fill the gaps left by the White Paper's changes. And finally, in respect of the settlement reforms impacting those who are already in the UK, there may be scope for legal challenge. I won't get too into the weeds on this here, but there is a concept in English law known as the doctrine of legitimate expectation. In the context of these settlement changes, the legitimate expectation argument would be as follows. Existing visa holders have relied on the government's promise that they would be able to apply for settlement after 5 years, and as a result of relying on this promise, they've incurred visa fees and various other costs. Now, if this argument were successful, it could make it more difficult for the government to apply the 10-year qualifying period to those who have already started on the path to settlement. However, the government will be able to rebut this argument if they can demonstrate that the 10-year qualifying period is in the public interest. That said, even if a legal challenge did not ultimately succeed, it could still help to somewhat delay the implementation of the 10-year rule. So, as we finish up, a few action points to take away with you today. If you're an employer, you should review the circumstances of your existing workers who have visas, whether they're sponsored by you or otherwise. If any of your employees have skilled worker visas expiring in the next few months, you might want to consider discussing an extension with them now so that you can avoid paying the higher skills charge. If you have any employees who are coming up to the 5-year qualifying period for settlement, then you may want to advise them to apply to settle as soon as they can. In the case of sponsored workers in particular, encouraging them to settle before the changes come into force may save you thousands of pounds in skills charge, as well as the administrative costs of sponsorship. You should also consider whether the skill level changes are likely to impact your business directly, assessing whether there are any particular roles or teams in your organization at risk. If you have vacancies in these areas, it may be worth moving to fill these now, while you can still sponsor workers from overseas or who are switching from other visas. You should also be assessing the increased costs associated with a higher skills charge, higher salary requirements, and a smaller talent pool, and budgeting accordingly for the future, particularly in those roles where you're aware that niche skill sets are required. If you're an individual who is hoping to apply for a skilled worker visa, whether from overseas or switching from another visa route, then we would recommend applying soon. The various proposals relating to skill level, the skills charge, and salary requirements should not affect you if you apply for your skilled worker visa before these changes are introduced. But once the new rules and rates are in force, sponsoring you may be a more costly and less attractive proposition for UK employers. If you're already in the UK and hoping to settle, then we would recommend that you review your current residency and confirm when you will hit the 5 years required under the current rules. If that date is coming up in the next few months, then we would encourage you to begin preparing your application and accompanying evidence as soon as you can, to give you the best chances of submitting your application before the new 10-year rule comes into force. I should flag that you can apply for settlement up to 28 days before you hit the 5-year mark, so you may be able to apply sooner than you think. And if you're planning to make an application of any kind, whether for your first visa, to extend, or to settle, it would be wise to double check the English language requirements at the time of your application. We expect that some people will be caught out by these changes and may apply with outdated tests at lower than required levels, as Victoria mentioned earlier. The increased demand for tests is also likely to make it more difficult to get a test slot at short notice, so it's worth planning ahead where possible. And of course, if you have any questions on any of this, please do get in touch. Speaking of questions, I think we can now move on to our Q&A section. Victoria, have we had any questions come in?
Yes, we've had a couple, Callum. I'm just going to read some out to you, and I think, Imelda, there's probably one in here for you as well. So the first one then is, I think, Callum, is probably related to you. So how likely do you think it will be that there will be any mitigation if an individual is close to settlement, and if you're able to give any examples of what that might look like?
Yeah, so as I mentioned, I think it's certainly a possibility, and it's been flagged as something in those BBC and FT reports that might be included in this follow-up publication to the white paper. I suggested that one possible approach might be if someone is a few months before the 5-year qualifying period, when these new rules are introduced, then perhaps affording them some leeway there and allowing them to qualify under the old 5-year rule rather than going through the new 10-year rule. So that's one possible way they could do it. It may be that they limit it to certain visas. So certain visas, they allow people to still settle under the 5-year route. It may also be that they look at things in the round in much the same way as we're expecting for these contributions to the UK society and economy exceptions. It's difficult to say really until we get that follow-up publication, but what I think is most likely is that it's going to be based on how close you are to settlement at the time that the new rules are introduced. That's my current expectation.
I agree. Mm-hmm.
Perfect. Okay, on to the next one then. So we've got a question here about individuals on visas, existing skilled worker visa. So we have 2 employees on visas, one on a skilled worker visa and one on a graduate visa. Both earn substantially below £50,000 per year. What does this mean for us?
So in respect of the skilled worker visa, they shouldn't be affected by these changes in respect of the skill levels increasing and that knock-on impact on salaries. Because their skilled worker COS was assigned prior to these changes being introduced, they shouldn't be affected. That's our expectation, and that's how it's been with previous changes in this respect. So it'd be quite a significant change in policy if the Home Office were to take a different approach this time round. In respect to the graduate visa, it's an interesting one because they're sort of falling between 2 stools. My expectation is that they would be subject to the new skill level requirements and therefore to the new higher salaries because they're not currently on a skilled worker visa. Even though the graduate visa is often seen as a sort of route into the skilled worker visa, they haven't actually started on the skilled worker visa yet. So in respect to your existing skilled worker visa, you should be fine. If we do hear anything to the contrary, we'll of course publish an update on our website. In respect to the graduate, however, you might want to keep an eye on those timescales in terms of these changes being introduced and potentially having a conversation with them about switching to a skilled worker visa sooner so that you can get them onto these onto the roles that you need them to be on at a lower salary, and also so that you can hopefully avoid the increased skills charge when that comes into effect.
Perfect.
Right.
Thank you. We're having quite a few coming in. So we are submitting our sponsorship application on 16th of June. The role is RQ3 and the visa application is for 3 years. If after 3 years the role is still RQ3, will we still be able to apply?
So I think what you're saying there is that there's somebody who's coming in, you're applying for a sponsorship license, and the role that you're applying for that sponsorship license for is an RQF-free role, and you're wondering whether in 3 years' time, after they've done 3 years on their visa, will they be able to extend? Yes, provided that they get their certificate of sponsorship and their visa before these changes are introduced, then you'll be fine. The only risk would be if your sponsor license application takes longer than expected and is delayed until after these changes are introduced. Then you might find yourself in a bit of a tricky position because obviously by that stage your candidate won't yet have their certificate of sponsorship or their skilled worker visa, and therefore they will be subject to the new rules. So it may be one where you want to apply for the priority service for your sponsor license so that you can get that as soon as possible, assign the certificate of sponsorship to this individual and get them their visa before these changes come into force. And then when they're extending their visa in 3 years' time, you won't have to worry about the higher skill level.
I just want to add something to that, Callum. In addition to the skill level, we would also need to bear in mind when we had some major changes to the SOC codes, some disappeared, the salary levels increased. So when extending, there is still a possibility of having to review and comply with the new salary requirements for whatever standard occupation code best suits the role at that time.
Yeah.
Right.
And I think there's 2 that are quite relevant to each other really, but I'll start with this one. Do we know what will happen to skilled workers who seek to extend their visas where their role will no longer be on that list of eligible occupations?
So yeah, my understanding based on what the white paper says is that they will be able to extend. They're unaffected by the changes to skill level. And so although those occupation codes will essentially disappear for new skilled worker applicants, whether they're applying from overseas or switching from another visa, for someone who's extending their skilled worker visa, they will be fine and they will be able to use the old code. As Imelda mentions, there's a possibility that the codes will be restructured, which we saw happen earlier in 2024, I think it was. And so you may need to double check that the code that they fall under is still the one that they previously fell under. But yeah, they'll be fine to extend.
Okay. Thank you. So the next one that was sort of in the same remit is we've got someone on a skilled worker visa, 2 to 3 years in. Once the changes as planned happen, if they do, and the time to naturalise is 10 years, is this expected to be applied retrospectively?
Yes. So as mentioned, the current expectation is that the settlement changes will apply retrospectively. So your employee, your skilled worker, they would be impacted by by the settlement changes. So even though at this time they could settle after 5 years, and they may have been in the UK for a couple of years by the time these changes are introduced, the current expectation is that they would have to wait the full 10 years to settle. Now, as mentioned, there's possibility of legal challenge. There's possibility of that being rowed back on or watered down, but that appears to be the government's current plan and the government's current policy. And so, yes, our expectation is that that person would have to wait the full 10 years, unless they fell under the exception regarding contributions to the UK economy and society. As I mentioned, we're still waiting for further details on that. We don't really know what that will involve or what that will require.
Right. Okay.
We might have time for one more, Victoria, and then
yeah. Okay, so we've got a relatively shorter one here. So will there still be eligibility for ISL discounts when applying for a skilled worker visa after recently graduating?
So is this for somebody so is this somebody who is applying for a skilled worker visa after the changes have been implemented? If that's...
Assuming so.
Yeah, so if that's the case...
The skills levy, is it? The immigration skills levy, ISL, I'm assuming they're referring to.
I think, well, or it could be the immigration salary list. I think might be what they're... Yeah, if it's the immigration salary list, then no, because that will be done away with. There is the sort of what is called the new entrant exception, which allows people to apply with lower salary rates if they fulfill certain conditions, and often if they've been studying recently, or if they're under a certain age. As far as I'm aware, there's been nothing said about that new entrant exception. And so I would expect that to remain in force, but it's possible that as part of these sort of broader changes to the skilled worker visa and to salary requirements, that might be done away with as well. I don't know if you had any further comments on that, Imelda.
No, that's all right, Callum.
Okay. We're running low on time, so I think we will have to leave the questions there, unfortunately. But thank you all so much for coming today. Before we finish up, I thought it would be helpful to quickly run through some of the key points from today's talk. The qualifying period for settlement is increasing to 10 years. And as mentioned, we expect this to also apply to people who are already in the UK. The cost of sponsorship is increasing with higher fees and salaries and fewer roles eligible for the skilled worker visa. We expect this to have a knock-on impact on all employers, particularly those operating in sectors affected by the skill level changes. Graduate visas will now last just 18 months, and the high potential individual visa increasingly looks like a more attractive option, disincentivizing international students from coming to the UK to study. Higher standards are being introduced across the board for English language proficiency, with a greater emphasis on demonstrating ability throughout one's stay in the UK. And there are further significant changes afoot in the care sector, with a ban on hiring from overseas. As it stands, switching into and extending visas in the care sector will continue until 2028. And that's all from us. So thank you again, everyone, for coming. I hope you found today's talk insightful and informative. Our contact details are up on the screen if you'd like to get in touch, or you can connect with us on LinkedIn. I should also mention that I'll be co-presenting another webinar with my colleague Annabelle on navigating employee grievance investigations. Mishandling grievance investigations, even unintentionally, can have serious consequences, from damaged trust in the workplace to costly legal claims. That webinar is taking place at 11 AM on Wednesday, the 9th of July. There's a link to register on our website, so please do sign up if you're interested. And just before we go, I should quickly add that if you stay on the line, there is a feedback survey that will pop up, as Imelda mentioned earlier, and we would very much appreciate it if you could complete this, as all feedback is really helpful to us in providing future webinars and training. There's also a £50 John Lewis voucher up for grabs, with the winner of this being drawn from those who complete the feedback survey. So if you want to get ahead of your Christmas shopping now, please do complete the survey. Thank you all once again for coming, and as before, please do get in touch if you have any questions.
Thank you all. Have a good day.
Thank you. Bye.